Lawyers of Reddit, what was your whole IT moment where you knew you would win? I had a client who was accused of taking a young woman's car and then crashing it, fleeing the scene. The girl testified at trial that she had given him the keys that night because she was drunk and would never, ever drink and drive. Apparently she was not aware that I had requested and obtained a copy of her driving record which showed she received a DUI a month after the incident. I still remember the look on her face when I handed her driving record to her and said, except for that one time you got caught a month later. Right? Double quote. The look on the judge's face was equally memorable. I trapped a defendant pretty badly one time. He testified in a depot he had a green arrow for his left turn and that my client ran the red. Unfortunately for him, the additional turn lane arrow was installed 2 months after the wreck. Case settled for policy limits a week later. I'm not a lawyer, but I took my old landlord to court when I was in college. They stole my security deposit over bullshit. They claimed I trashed the place, not knowing that I took pictures and video when I moved in and out. Their evidence was a VHS quality recording of going through a perfectly clean apartment in better condition than it was when I moved in. But then they opened up the top of the stove and found a single piece of elbow macaroni under it, holding it up triumphantly. That was the crux of their defense. The judge was not amused and I got all my money back plus my lawyer fees and the filing fee. She then fought against her own lawyer to avoid paying him. Asshole. Edit. Anytime you move into a place, take pictures, take video, make notes about any damage. When you move out, do the same thing along with noting any repairs you made. Pretty hard to argue against solid evidence. Protect yourself. It wasn't a trial, but during a deposition on a case where 2 former employees decided to start their own company in a very niche market, but decided to make their plans on company laptops they unsuccessfully tried to brick. One of the defendants was the one being deposed. She said she answered to a higher power than the company. When pressed on what that meant, she said herself. That got reused prominently at trial. I was sued for a car crash. While the plaintiff was on the stand, she began recounting the event and everyone realized it was a completely different crash. Different cars involved. Different time of day. Everything. Upon cross-examination, she revealed that she had 4 lawsuits running concurrently and couldn't keep them all straight. The jury foreman looked at me and rolled his eyes. Her eventual payout, paid by my insurance co., was a pittance. Less than the initial settlement offer before the whole thing went to trial. Her lawyer was shaking with anger when court adjourned. He was one of those "we don't get paid unless we get money for you guys." So he lost a lot of money on that one. My client has been keeping her son away from the father because the father has a new child. She is concerned that her son will act violently towards the new child and she could be held liable. Double quote. Judge, that's not even a defense. Double quote. Man, this sounds like a really sad family situation for the older half-brother. Sounds like his mom is pissed that his dad has moved on, so she refuses to cooperate and wants her kid to hate his dad and the new baby. I worked on a case involving defective processors. In discovery we got emails from the defendant's engineers that had worked on the processors. They were in an Asian country but the emails were in English because they were going to US executives. One of the more senior engineers basically laid out the exact defect we were suing over, explaining what the problem was and why it was their fault, and finishing with "this is big problem. We ship crap to customer." Double quote. Needless to say we hit them over the head with that in mediation, and they settled shortly after. My client was accused of brutally murdering a dog. Cop testified that there was no testing of the blood. No body ever found. And admitted it could have, in fact, run away. The eyewitness said she could see the killing down the hallway from the dining room. Cop testified there was no hallway and the dining room was on a different level of the house than the killing supposedly took place. Then the person who was leading the lynch mob against my client around town for the last year testified that she had been in the apartment between the 2 visits by the cop to evaluate the scene. No body. A compromised crime scene. Witness who couldn't see anything. and admission that there was no proof the dog was dead. Closing argument lasted 3 seconds. Your Honor, I'm asking for an acquittal. Edit. My first award. Thanks. For those who asked, this was in Canada and received a fair bit of media attention prior to trial. My mom hit a guy on a bike with her car in a parking lot. She claimed he hit her. She also wanted to counter-sue the cyclist for scaring her. In her deposition she started every sentence with "when I hit him." Double quote. Them. This document doesn't state our company's name, so we are not involved in the settlement. Double quote. Me. Line 4 specifically lists the company as the defendant, and then the company is referenced to in lines 13, 27, and 33. Double quote. I swear, if you read the documents, you're a better lawyer than 90% of the ones out there. Not lawyer, but represented myself in court. Got a parking ticket and contested it due to misleading signs. Took a bunch of pictures and brought it to court. Judge agreed and dismissed the case. Hold up. What about the towing fees, I asked, as he was about to read the next case. Got those back too. Close bracket. When I was younger I was being harassed by some debt recovery agency over money I didn't owe. Fees added to fees for a store card I'd closed out years before. I applied to have the debt set aside, which is basically where you challenge the debt recovery agency to prove you owe the money or lose the right to contact you about it. I turned up to court and the debt recovery agency didn't. The judge was so pissed. She asked me to estimate how much the inconvenience of attending court cost me. And when I told her my estimate, around you accrued $600 with travel, time off work etc., she said you accrued $1,200 seems reasonable. 2 weeks later I got a check for you accrued $1,200 for refusing to pay some bogus fee. I clerked for a judge and we had a low-level thief in our courtroom who had robbed one of his neighbor's houses in the winter in Colorado, and all the police had to do was follow the footsteps back to his house where he was hanging out with the stolen items and a small amount of drugs and a shitty handgun. Idiot. Edited for clarity. Ian Albert, a friend of mine, was a DWI attorney in New York for a while. He was defending a guy who was asleep in the backseat of his car while intoxicated, and a nice trooper arrested him. On the stand, the trooper testified that he visually saw the key in the ignition. Double quote. My friend gave him like 3 chances to walk it back. Are you sure, trooper, that you actually saw the key in the ignition? Double quote. Yes, counselor. Comma, when a cop calls a lawyer counselor he really means asshole. And then my buddy dropped the hammer. You are aware that my client drives a Toyota Prius? Double quote. Bam. Obligatory. Not mine but my mom's story. She was fighting for custody on behalf of the father, trying to prove that the kids were living in subpar conditions with their drug addict mother in spite of the ample child support provided. It was a tough case because courts are so hesitant to pull kids away from their moms. Then the mom burst out that she had been feeding the kids cat food as proof that she wouldn't let them starve. Needless to say, the judge didn't take that as a good reason for the kids to stay with their mom. The plaintiff was being deposed in the lawsuit she filed alleging sexual discrimination. She was claiming her boss had made some inappropriate innuendos and overtures. The defense attorney asked her if when the alleged statements or events took place, was she shocked? No. Was she offended? No. Was she damaged in any way? No. So why exactly are we here? Well, honestly, I'd rather not be. Meanwhile her attorney stared straight down, scribbling notes, doodling. We ended the deposition there and asked her attorney if this was going away now. We got a call later offering to settle for $1,000 and a letter of apology. My best guess is she was pressured by a friend or family to talk to an attorney and the lawyers ran with it without really talking to their client. This was actually fairly recent. I was in a deposition of a fact witness to an automobile accident in which my client was killed. The defendant's attorney had called the deposition and over the course of an hour and a half or so elicited a lot of testimony which seemed to place my client partially at fault, which would impact my client's, edit, Financial recovery. After sitting quietly for an hour and a half, I asked less than a dozen questions. The last of which was about the specific location of my client when he had first seen them. Based on his answer, it was clear that my client couldn't possibly be at fault. I sent a follow-up letter that same day and the case had settled within the next 2 weeks. Moments like this usually happen at bond hearings for me. It almost never fails. If the judge starts by saying something good for our side, he's going to deny bond 9 times out of 10. But if the judge starts by saying things like how these are some serious allegations and although he's not prejudging the case, there seem to have been some bad decisions made, etc., that's usually just the judge trying to put the fear of God in the defendant before granting bond so he'll behave while out on bond. I knew the cops beat up my client and framed him. They described a knife in his possession that caused them to fear for their safety. Oddly, they never seized it. We won the criminal case and filed a civil rights case. While deposing one, he described the knife in detail. No more than 3 minutes later, he slipped up and claimed his partner told him my guy had a knife. But he never saw it himself. I told him, "That's not what you just said," and saw him panic. His lawyer panicked too and asked to see me outside. When we got in the hallway, I withdrew my settlement demand. And the case settled for a substantially larger amount within 45 minutes. Not exactly a knew you would win moment. But I got a hidden shout out from a federal judge in a ruling that I consider to be one of the high points of my career. Here's what happened. Before a hearing for an emergency injunction against USDA, I was watching the hearing before mine, a trademark infringement case. At the end of that hearing, the judge accidentally used a pun and could not stop laughing. She was literally crying. I decided at that moment I was going to intentionally use a pun in my hearing. I did so. He accused USDA of engaging in a shell game by illegally diverting some federal funds to an egg industry trade group. The judge called me on it, but laughed heartily. My client won. The judge threatened to put the Secretary of Agriculture in jail. A major newspaper reporting on the case said the judge winced at my puns but agreed with my arguments. False. When the written ruling was issued, the last sentence said that an injunction was issued against USDA's use of the funds for any plans they may be hatching. Undeniable shout out. My attorney had this moment in my initial consultation with him for my BWI charge. Yes. Boating. The sheriff's department conducted the field sobriety tests on the deck or their small vessel in a heavily traveled waterway rather than taking me to drier land. Charges were thrown immediately out after my attorney brought this to the attention of the DA. Edit. I should add. This attorney was a sheriff's deputy on Marine Patrol for 12 years prior to going to law school. I interviewed 3 different attorneys and he was the last. The other 2 quoted me $3.5K for the defense. He said that he would never tell a client a case is a slam dunk, but he charged $700 and said he would see the case through trial if it didn't get dismissed with no additional fee. It was thrown out by the end of the week. When the other side states an unsupportable position, and them being other lawyers, it happens more than you think. Especially when you're in an industry with entrenched firms that get to dictate the discourse and standard of practice. Doesn't mean they're right. It's easy to tell when they're wrong. It's just a matter of fighting it to prove it. Not my case, but my husband handled a paternity case pro se. His ex was trying to take basically full custody of their son and only give him visitation 2 days a month. Her reasoning was that he wasn't involved, didn't go to doctor appointments, didn't take the kid to school, etc. My husband asked her, "When was the last time you told me about his doctor appointment?" She thought for a second and said never. He asked, "Would you have let me take him to school if I had asked?" Again she thought for a second and said no. Needless to say, they got 50/50 times sharing with joint custody. Not a lawyer, but I'm currently in a custody battle. Mother is saying I can't be trusted because I've been refusing to take our child to the therapist. The therapist testified I couldn't bring our child in because therapy must have both parents' consent. And mother has retracted consent. When I found a video on Facebook of the plaintiff squatting 300 pounds the month before his deposition. That was a good one. Oh, he was saying he couldn't work and had back injuries after a minor car accident. These sorts of people make my blood boil. My dad hurt his back badly when I was a kid and it took him years to be totally pain-free and have full movement. Even now. Like 20-25 years later his back iced 100%. I was once representing an intellectual property owner as a plaintiff in an IP lawsuit against a large company alleging they stole his IP. I managed to depose their CEO over their attorney's numerous objections and motions for a protective order. I found some paperwork submitted to the US Patent and Trademark Office that would technically be fraud if submitted incorrectly. And that he as the CEO has signed personally. At the time he signed it, he was literally on parole for a previous white-collar crime. I grilled him in the deposition on how the facts that he signed were technically not accurate. And since he was on parole when he fraudulently signed this document, he was committing a federal crime which would put him back in prison for violating his parole. He was extraordinarily uncomfortable. Paused the deposition. And we settled on my client's terms right that very day with his attorney hemming and hawing and begging him to stop and not settle. The depo transcript never made the light of day. My client, the plaintiff, was in a huge car crash where my client's car literally caught on fire. During closing, the defense claimed that my client's shoulder spontaneously dislocated because it had done so 9 years previously. The defense expert conceded there was evidence that the crash probably aggravated her shoulder. The look on the arbitrator's face was priceless during the defense closing. After the defense closing but before my rebuttal, the arbitrator asked defense counsel so many damning questions that my rebuttal was less than 5 minutes and solely on damages. The judge awarded 8 times the defense's last offer. I have edited for clarity. I did not realize how tough drinking wine, watching the croods with my kids, and typing out a coherent internet story was until today. Just a reminder. People, discovery is a thing. Be dubious of any story where, during a criminal trial, a lawyer pulls out surprise evidence the other party wasn't aware of. If evidence wasn't presented during discovery, it cannot be used in a criminal trial. Unfortunately, I'm seeing a lot of top-level replies being exactly that. These stories are either embellished, outright fabricated, or failures in proper due process on behalf of OP. When the prosecutor got all emotional and threw fits, that was a good sign. At a restraining order trial, it was essentially my client's word versus his. Regarding a sexual assault. He did a good job dressing up and acting very appropriate during most of his testimony. But then he was asked a series of open-ended questions and he said something to the effect that, "She kept coming up on me with that f***ing pussy," allegedly during a lecture, and as soon as he said it, a look came on his face and the judge's face and everyone knew the ruse of respectable young gentleman had failed. I won. Very abbreviated. I was prosecuting a convenience store owner for luring a young girl, who regularly came into the store, back to a part of the store to grope, fondle and kiss her. Child enticement. It was the only section of the store without surveillance camera coverage. They were in the back room for about 2 minutes and 17 seconds. Put the timestamp on the videos. Of the many arguments the defense put on, one was there was no way there was enough time for anything to happen. In my rebuttal on closing, I asked the jury to imagine what could happen in the room in that amount of time. And I asked them to all close their eyes while I timed out 2 minutes and 17 seconds on my watch. In silence. After about 60 seconds, 2 of the jurors started crying. Knew it was going to be guilty right then. My firm was attempting to hold Grubber Pharmaceuticals accountable for polluting Frog Lake. And my old law school buddy Brad was the lawyer representing the defense. I felt it was an unfair case since his main tactics were to impress the women on the jury with his good looks and perfect body. My whole IT moment was when he showed us a video of himself swimming in the lake and proclaiming that it was perfectly safe. But I asked him to take off his shirt, which everyone agreed to, and he had acute dermatitis all over his body. That's a win-win for me. The plaintiff testified to being able to walk 2+ miles to and from their chiropractic appointments each time. I understand these sorts of examples are often used as gotchas, but I don't truly get it. In context, a person in pain can be suing in good faith while still trying to live their life. Do attorneys ever feel bad discrediting a legitimate victim by building a misleading narrative like that? Not saying that's how it was in your case. Genuinely curious though. It was day 2 of a child custody modification trial. The opposition and her attorney were and are batshit crazy. Their allegations were so weak that I told my guy, fuck it. Let's go for custody ourselves. I'm cross-examining mom about her proposed custody plan for dad in some detail, and I ask her, would you accept this for yourself? Double quote. She snaps back, absolutely not. Double quote. I ask, why not? Double quote. Because I'm a mother. To his credit, my guy kept a straight face the entire trial and never once got pissy. Her petition was denied outright. Ours was accepted by the court. If the mom or her lawyer hadn't been such pains to deal with, my guy probably would have agreed to some small reductions in his custody just to keep the peace. Instead, the judge gave us nearly everything we asked for. My client was riding his motorcycle on a relatively calm street when this guy exited his garage without looking and run over him. In deposition, the guy brought a witness that was with him on the passenger's seat the whole time. The witness maintained that my client was driving too fast and that there was no time to brake the car. I asked him the same question a few times in different ways, making him tell the story again. In the fourth telling, he, already a bit frustrated, let it slip. Look, I've already told you. We were exiting the garage and as soon as I lifted up from getting my cell phone on the car's carpet, wait. So you didn't even see the crash? There was no coming back from that.